My name is Brendan Sharkey. I'm a partner in our property department and I'm going to talk to you today about the Multi-Unit Development Act. It's been in being now for a number of years and I want to examine whether or not it's been a success. All sections of the Multi-Unit Development Act 2011, they were commenced with effect from the 1st of April 2011. The Act was introduced to seek to address problems relating to ownership and management of the common areas of both existing and future developments, which contain a multitude of units. The Act also seeks to facilitate the fair and effective management of bodies responsible for the management of those areas. Given the Act has been in operation for a number of years, now the question arises, has it been a success? It is clear that the body of the Act itself has introduced a number of legal measures which are of benefit. For example, in new developments, by which I mean those commenced post 1st of April 2011, a developer cannot transfer an interest in a residential unit unless various conditions have been complied with. For older developments, meaning those which have been sold pre 1st of April 2011, the Act prescribed a 6-month time frame within which the common areas should be transferred to the OMC, which is the management company. Purchasers of residential units automatically become members of the OMC on the acquisition of a unit, and only residential units have voting rights in the OMC, with one vote attaching to each residential unit. The OMC must now implement a fair and equitable service charge structure, and the service charge budget shall not be levied unless it has been considered in general meeting by the members. A sinking fund must be established to deal with certain expenditure incurred, and the OMC has the right to effect essential repairs on parts of the development which are not in its ownership, where those repairs are necessary for the safe occupation of a unit, and they can seek to recover the expenses from the person who is responsible for the work. The benefits of any warranties and guarantees received by the developer in relation to the MUD, meaning the multi-unit development, shall automatically transfer to the OMC. In terms of the overall impact of the Act, it is clear that the position of an OMC is now a lot stronger than prior to its implementation. It is appropriate to examine the benefits of the Act under a number of headings. Firstly, looking at general governance. Members of an OMC now have clear transparency and more input to the management of the OMC. Voting rights are now prescribed, as is the ability of the members to consider the service charge budget prior to its implementation. In addition, the obligation to provide for sinking funds means that, in theory, the OMC will have funds available to meet a contingency should it arise. Secondly, looking at new developments. From a conveyancing perspective, the benefits of the Act are more clearly visible in new developments. We are now seeing that where residential developments are being constructed, that the common areas are being transferred to the management company at the outset in compliance with the Act, and that the relevant documentation required by the Act is being furnished. Thirdly, in the context of older developments, whilst the Act does impose an obligation to have common areas transferred to the OMC for such developments within 6 months from the 1st of April 2011, from my experience, this obligation has to a large extent not been complied with. In many cases, the developers have become insolvent, banks or other vulture funds have taken possession of the developments, and compliance with this provision, it does not seem to be a priority. One of the main failings of the Act is that a sanction for non-compliance with this section was not imposed. Furthermore, the Law Society has indicated that the non-transfer of common areas to a management company in such developments in compliance with the Act is not a blot in the title, and therefore conveyances of such units occur normally at present, notwithstanding non-compliance with this requirement. Therefore, to conclude, the Act does clearly enhance the position of the OMC and its members. The onus does, however, lie upon the OMC and its members to ensure that the rights conferred by the Act are being respected and complied with. This requires an OMC and its members to be familiar with the Act, and to fully obtain the benefits of the Act, members must become actively involved in the management of the OMC. Of course, there are many OMCs experiencing difficulty in collecting service charge, and they may just be solvent. In such cases, the suggestion of establishing a sinking fund of any significant, or indeed bringing actions to enforce rights under the MUD Act, may not always be an option due to lack of funds. That said, the Act is certainly a step in the right direction. If you'd like any further information on the topic discussed here today, then please feel free to contact me directly. My contact details are on our website. In addition, we have a selection of articles on such topics on our website which you may like to view. Thank you.